Lighting is now in session. Please be seated.
Good morning, everyone. Oh, okay. Welcome to the First District Court of Appeals. Looks like we had some traffic issues today, so our cases are going to be taken out of order than what's on the schedule. We have 3 cases that are set for argument today. 2 are going to be live in the courtroom, and then 1 is going to be after we conclude court in here. It'll be on Zoom. The first case set for argument today is Carter v. Carter. Will the attorneys please state their appearances and their readiness to proceed?
Thank you. Christopher Challenger, 0084027, on behalf of the appellant, Jeanette Carter. Good morning.
Good morning.
Morning.
Good morning, Your Honors. Erica Underwood, 0067664, on behalf of Tim Carter. And I am prepared to proceed.
Okay,
Thank
thanks.
you.
And you don't have to say your attorney number. And then we do have, I think one of the attorneys is going to be late for State of Ohio versus Sherman. I think we have Ms. Creer here for the state.
Candace Creer on behalf of the State of Ohio.
Okay, and then Mr. Gustafson is on his way, is my understanding. And then the final case that's set for argument on Zoom is Edelston versus Edelston. And for anybody that is watching our live feed right now or in the courtroom, we will conclude court after our second case, and then we'll be back on in a separate Zoom broadcast after this. All right, so we will start with Carter versus Carter. Mr. Trollinger, would you like to reserve any rebuttal time?
He has 3 minutes.
Okay, I'll keep your time. You'll see the buttons on the podium. Green is go, yellow is you have about a minute left, and then red is you'll be at the end of your initial time, and I'll reserve your 3 minutes. Whenever you're ready.
All right, thank you. Good morning, counsel and judges. This is a case coming out of a divorce, both that happened as a magistrate's decision. Objections were made by the appellee. Then ultimately an appeal came before this court one time prior. This court then reversed that decision, instructing the trial court to make further findings and justification as it relates to the issuance of both the amount of spousal support and the duration of spousal support, specifically as to why that specific number was chosen and why the magistrate's decision was rejected as it relates to the amount that the magistrate found, despite the trial court maintaining much, if not all, of the actual findings of the magistrate. What occurred on remand was the issuance of a decision in which essentially one additional small finding was made, indicating that the trial court judge did not believe that Mr. Carter would be able to gain employment greater than the 3-year average that the court found. However, there's no actual justification related to the actual finding of spousal support. When you look through the factors of spousal support, not only is it incumbent upon the trial court judge to provide enough findings and conclusions for this court to do a meaningful review of spousal support, but if you look to the actual findings, it's not justified and would equate to an abuse of discretion, given the totality of the factors as contained within 3105(1)(8).
Go ahead.
Didn't the trial court determine that his physical injuries would prevent him from earning a living at the level that he had prior?
Specifically, the trial court found in its findings is that while he was injured in 1998 and had worked and was the primary income earner, the ultimate finding was that the trial court judge found that he was not likely to earn an income greater than the 3-year average. Not that he wasn't going to maintain that income, just that it was not likely that the trial court found. And I would proffer to the court that may be a justification as to why you keep a duration or you keep jurisdiction, but not any sort of justification or further finding as it relates to the amount of spousal support, and given the fact that both the trial court judge and the magistrate found the same incomes.
So your specific argument on appeal is what? Is it that spousal support was awarded at all? Is it duration or combination? is it the amount?
It's the amount and the duration as far as the abuse of discretion
Not that
goes.
spousal support was awarded.
Correct.
Okay.
And in fact, the appellant did not object to the magistrate's decision. It was the appellee who had objected to the magistrate's decision.
Because it was too low.
But correct.
And he was asking for $2,500 to $3,000 a month
That is correct.
and ended up with
Approximately $2,100.
less than that. Okay,
$2,086
okay.
and some change. It's a very specific number. and
Well,
so-
that's the question.
Right.
And so a couple questions on that. You know, we have to determine whether the number is fair and equitable. And I was trying to figure out how the court maybe arrived at that number. And do you have any idea where this came from?
No, and that is further the problem, right? This is almost the second verse, same as the first. This was the issue that was brought before this court with, which reversed and remanded it, saying, please provide further explanation as to the amount and duration and why that differed from the magistrate's decision. What we got was a decision that didn't do that. They did not follow the mandate, and the remand instructions of this court is contained within the argument. And if this court looks at it and says, well, it's inequitable, and based on the findings, this court could find a specific ruling and grant the 500 amount based on the magistrate's decision, as the trial court did not follow the mandate the first time.
How do we do that? How do we determine whether, because looking at case law, it sounds like there's no mathematical formulation that's required, and I know the court has to go through factors, but how do we determine whether the court's amount that they land on I mean, we don't substitute our judgment, we just have to say, okay, this seems fair. How do we figure that out?
By looking, I mean, you do have to look at the factors in the abuse of discretion manner and say, look, this is, if you do the math of what the incomes were and see the evidence and look down and see what the net incomes are going to be, and then you also look at the debt load that was ordered in the trial court under the 3105-18 factors, it's clear to look that there's not enough money to satisfy all of these obligations. It just simply, the math doesn't work. To go from a $500 amount to now a almost $2,100 amount in a month, while the trial court also layered on additional debt that the magistrate didn't do. And we have now a higher spousal support. I think you can find an abuse of discretion based on the facts as found by the trial court. Under Appellate Rule 12B, this court can ultimately substitute a judgment based on the fact that the first appeal that reversed and said, please explain your math and logic for us, and then the trial court not doing that, can insert its own judgment to skip this repeat
I don't
occurrence.
think we said to explain the math. I think we just said to explain your logic of how you arrived.
At
And-
the
and-
amount
'cause I don't
and
think
duration.
any court has ever required a mathematical explanation.
No, correct.
Okay.
Just how do you come to that amount and duration? And the trial court
So
didn't
didn't the
change.
court provide some rationale for what it did?
No, I don't think it does. It goes through certain factors, as the magistrate found, but without identifying that the court didn't believe, there was no finding in the magistrate's decision, truly, that there was, what the income stayed same. It's a 3-year average. Both the trial court judge and the magistrate found the same income, without any justification as to why such a drastic increase from $500 to 4 times that.
Well, wasn't the rationale, he is not going to be able to earn that going forward?
That was one additional finding that the magistrate found, is that she didn't find it. Now, I don't believe that that's any additional rationale for this court to do a meaningful review, because it doesn't seem to, if that goes to amount the duration, I would almost concede that that would be more of a duration argument, keeping jurisdiction for both parties. If he does gain greater employment, or if he goes less, the parties can come back and ask for a modification during that window of time.
Well, isn't that true anyway? Doesn't the court maintain jurisdiction going forward?
Yes, yeah, the court maintained jurisdiction
So
over amount and duration.
if he got some employment going forward, it could be adjusted, theoretically.
Sure. But in the meantime, we've got 2 years in the past in litigation that have been going on, and she made it retroactive. So you're also stuck with that math backwards.
Can you
which
give
from
us
a-
an example of what you would have liked to see the trial judge do as far as explaining how she landed on the amount?
Sure, I think, and going through what the net income of, looking at the pay stubs, looking at the net income, seeing what, because spousal support is net of taxes, but also identifying a specific determination of both the debt load that we have and what are those monthly payments and the obligations that was put upon. That's a big factor in this particular case, considering how disparate the marital debt as well as what was the student loan debt. It's almost $200,000 of debt that the appellant has been taken on compared to much less of the appellee.
So you're looking really at your client's ability to afford the payments?
Yes.
That is part of the calculus?
Absolutely. So we've got not only the net, what it does to the net incomes from a equation standpoint, as far as, is this an equalization, is it less than, what are we looking at net of taxes, but also the ability to actually meet the burden of what the obligations were that the trial court placed upon the appellant with that spousal support award. Because you have to consider both, because you can't just both say, hey, you have to pay all of this debt and you have to pay all the spousal support when the numbers are finite.
Are
It
you-
seem,
Go ahead.
well, it seems like her debt amount, the gross debt amount is very large, but the actual monthly payment is not.
Only as it related at that time, related to the student loans. The
What
other,
was the total dollar amount of the student loan?
it was $151,000.
And the remainder,
The remainder of that was $47,000 of credit card debt.
all right. And then, but the payment on the student debt was not a burdensome monthly amount.
It was in a deferral status with COVID at the time of the trial, so it was $50, but at the time, the direction from the court was that at October 1st of the year, it was going to go up. It was just an unknown amount.
But then she could go back and get an adjustment
Sure,
if her monthly payments went up.
sure. And conceding the fact that the student loan debt would be $50, if we say that, and obviously you're never getting out of that debt at that kind of a payment. But if we concede that point, still with looking at the credit card statements and the amount of debt that's associated with the credit cards, her ability to continue those payments would also be impossible given such a large spousal support.
What does the record say about the amount of money that she had to pay per month on
The
the
record
credit cards?
indicates, and I'm not sure I have it in front of me because it was all of the credit card statements. Let me see if I've got it here.
If you don't have it, we can go back and look. I was just curious if you knew off the top of your head.
I don't have that number off the top of my head. I have the totals and the percentage of the marital debt that was ultimately ordered to Sherette Carter to pay.
Now, are you challenging any determination of a specific statutory factor made by the trial court, or just the amount that she landed on?
It's both, it's the process and the clarity, the lack of justification to get to that number.
But is there any specific statutory factor that she found that you disagree with?
No, I don't think so. I mean, the facts were as the magistrate found them. There wasn't a change. The only statutory factor that I would take issue with is the fact that she laid on additional debt to Sherette that the magistrate didn't do, but then doubled up on that with an additional large spousal support amount.
Does the record reflect the source of the credit card debt?
The record reflects that it was marital debt accumulated. Both the testimony of the appellee indicated that he knew there was a Right Pac credit card that had been racked up for $25,000. It was maxed out, as what he indicated in the record. The other side of, there was kids at the time of the marriage that were going on, as well as the fact that she was in school.
But there's nothing in the record that reflects with any specificity what those credit card debts were? Like, are those,
No, and under the statutory presumption, the presumption is their marital unless they're proven to be separate. And there's nothing in the record that would indicate they were separate
Okay.
debts.
So again, and just so I understand, because a trial court doesn't have to do a mathematical calculation for us to review, what specifically should a trial court be doing in your view, so we can properly review the amount of spousal support?
Sure, I think there has to be some sort of a recognition of what the actual impact of the spousal support to income as well as the total picture of the debt situation is. There has to be some analysis of the equitability. You can find all the factors and say, okay, here's how much debt she has, here how much debt this is. And then if you just come down and say $2,100 is the number for 5 years, without linking those factors to what the actual finding is, that is where the trial court went wrong in this particular case. If the math could be shown to say, okay, I understand here's how much the monthly payments are based on this debt, here's what the obligation is, here's the net income after spousal support, and this is equitable. That kind of analysis, and I'm paraphrasing for the court, but that's the impact that spousal support has on both parties, is what is not in the record. It's not in the factual conclusions or findings. It's simply, we're making factual findings under 3105-18, but we're not making the equitable determinations as to what is going on.
So it's not just trying to make them even in their monthly amount of income, it is also taking into account the impact on the person paying spousal support and all of their additional debt obligations.
Correct.
And that's where you said she fails.
That's correct.
Okay. And I'm sorry, I got wrapped up. I will save your time for rebuttal.
Thank you.
Ms. Underwood, I'll give you a couple extra minutes if you happen to need them.
I don't think that
Okay.
thank you very much, Your Honor. Can't see the light.
You can't see the light? Okay, well, we'll have to have our tech people look at that. I guess it's useless anyway.
May it please the court, Your Honors, co-counsel. So obviously, Mr. Carter would argue that the trial court made a proper determination. And what Ms. Carter fails to argue in her appeal is, number one, that she was sanctioned for not responding to the court's mandatory disclosure order. And in addition to that, several discovery requests that occurred during the pendency of the litigation. Namely, on the day of the trial, she showed up with additional debts that the magistrate accepted as evidence, but when the objections were filed, the judge reversed that, issued the sanctions, and ordered her to pay those separate debts by herself because she came to the court with unclean hands, so to speak.
So you don't think those debts should be taken into account in determining her ability to pay the spousal support here?
No, the court issues mandatory disclosure orders at the time that a person files divorce. So,
Which debts were those? Were those the credit card debts?
those were some of the credit card debts, namely, there was $32,944.99 worth of debt that she never disclosed to the other party, never disclosed to the court until the second day of trial. She showed up with an affidavit of income and expenses that had never been revealed to the other party, never been revealed to the court, which had these additional debts on them. Mr. Carter objected during the trial, during the hearing. The magistrate overruled those objections, accepted that information, and when it went up on objections, then the judge decided or made the determination that she should be responsible or solely responsible for that portion of the debt. So the other debts were divided evenly among the parties, but just that portion of the debt that she had not disclosed was not. She was responsible for that portion, which is the $32,000 amount.
So that comes out of the calculus here, is what you're saying?
Yes. In addition to that, Ms. Carter argues that the court discounted the $153,000 in student debt that she has to pay. However, $93,363.49 is debt related to her educational loans. $60,386.15 were Parent Plus loans. And again, this is not something that she had disclosed during the course of the litigation. This came out during the trial during the trial. And again, Mr. Carter objected. Over his objection, the magistrate accepted those numbers, but then the judge, after the objections, made the determination that the $93,000 number was more appropriate.
But we're still, I mean, this sounds like she's being sanctioned here. And aren't we still required to consider her ability to pay as part of our review of the fair and equitable, whether the spousal support is fair and equitable?
Yes, so, and the court actually did do that. Ms. Carter actually had a six-figure income at that time from Formica. In addition to that, she had several businesses which were also disclosed during the trial of the matter. She was ordered to turn over income tax returns, and she was ordered to turn those over by a certain date. She never did. She still hasn't.
Okay.
So it seems like you're saying the trial court thought there wasn't a full disclosure of the assets of the wife.
That's correct. And based on the information that she had, she certainly considered those factors, and she did, the trial judge did enumerate the factors that she considered, but, in addition to the factors that she considered, that the magistrate considered, there's also the tax returns, the debts that weren't disclosed, and that portion of the student loan, which is not attributable to Ms. Carter, but was attributable to a Parent Plus loan.
So why is the Parent Plus loan different?
I'm not certain. I wasn't representing at that point in time, so I'm not certain why. But I do believe that Mr. Carter did encourage her to go to school to further her education, to make their living situation better. So he encouraged her to go to school to get her master's degree, and I would presume that that would be the reason why that portion of the debt that he encouraged her to incur to make their living situation better.
That's the 93 though, right?
That's the $93,000.
So what was the other amount for?
It was a Parent Plus loan,
For a child?
a child. And I'm not clear from the record which child it was.
But it wasn't for both of their benefit?
I'm not certain.
Okay. So do you have any idea, because it's, very strange that this number has 66 cents at the end.
Right.
Do you have any idea how the judge landed on this number?
I have no idea how the judge landed on the number. And what I
Okay.
will say, just in dealing with judges making spousal support determinations, you can never figure out what their calculations are because nobody has ever required them to have a calculation. We can guess, but I have no idea. And I do agree that the 66 cents means that she probably did have some calculation she considered, but I'm just not certain what that would
She
be.
hasn't revealed that to anybody.
No.
How do we, as an appellate court, determine whether this is fair and equitable?
I think that what you all have to do is just look at the entirety of the record. So the things that the trial judge did consider, like, for example, that the mandatory disclosure orders were not followed, that there was a significant amount of debt that was revealed on the second day of trial. Those mandatory disclosure orders are issued for a reason. They're given to you the day that you file your divorce or the day you file your answer and counterclaim. It's specifically so that people are not hiding assets and they're not hiding debts, and that the court can make a fair and equitable determination and distribution of the assets and division of the debts.
And the wife was running these businesses and incurring 30 grand in debt during the marriage, is that right?
I don't know that the debt comes from the businesses. Those were
No.
credit card
Separately,
debts.
right, but she was incurring that debt and running the businesses while they were married,
Yes,
and husband was unaware of those issues.
he was unaware.
So he could not have raised that question during the course of this discovery.
That is correct. And the court did order that she turn over income tax returns. Those never were turned over.
Is it proper for a court to order a higher amount of spousal support as a sanction for failure to disclose assets?
I'm not sure. I just know that all she can do is kind of make the best decision she can make with the information that she has. And it seemed that, she considered the income. Obviously, there were businesses that had not been disclosed. There was no way for the court to know what the income was from those businesses. So she was probably left, and again, I'm guessing, she's left in this position where does she ignore the fact that this business exists, or does she take that into consideration somehow and to craft a number for the spousal support?
I think that's just where my problem is that we're just sitting here guessing what she did and why she did it. And I'm just trying to figure out precisely what a trial court is supposed to do and say. I know it's not a mathematical calculation. I know there's not a formula, but I'm also trying to figure out what needs to be said for us to be able to review.
I don't have the answer to that.
Okay.
Any other questions for me?
No, thank
That's
you.
all I have. Thank you very much.
Thank you.
Mr. Trollinger, you have 3 minutes.
Thank you, and just respond briefly. Much of the business issues and that sort of thing were not really of the record in the trial court, nor the timing of that. Specifically, if you look to the remand entry, there's only B, C, I, and A delineated from what the trial court did as far as on remand. Those are the 3 different sections as it relates to spousal support that identifies that. It still doesn't get us to how do we get to this number and why. To answer the question that was posed to counsel, whether or not 3105.18 allows for a court to sanction a party on spousal support, the answer is no. That relies on 3105.171, which allows for that. Now, I would also posture, other than the fact that there was an order of discovery order, but the debts actually were disclosed. I mean, it was late in the game, but it's not a situation of secreting assets or secreting these things. It simply was brought to the table upon change of counsel.
If a court, you're saying this is not the case, but if a court thought that the person was secreting assets, then there could be obviously a higher support amount. in that
Yes, I mean, if there was a situation in which there's, now you've come up, we found that you've got $102,000 squirreled away over here, those questions come up. How did you get that money? Where did it come from? If you're making what you said you're making, it's unaccounted for. Those are the kind of questions that if they believe that you're making money, then the income goes up. Now, if it's an asset problem, it's still a 3105.171 determination. And those determinations have to be made before 3105.18 under the rule, because the 3105.18 requires that that the court takes into account those divisions. And it doesn't say, well, we're not going to take into account if there's a sanction levied or if there's more debt given or anything. It is the actual, what are the assets, liabilities, and obligations of the parties, regardless. And again, to the court's point, there's simply nothing in the decision that gets us to that number or how to understand where the court came from to get that number. Very specific number that was issued, given the fact that the magistrate's decision was, for the most part, factually left unchanged. And we'd ask the court to reverse and remand and/or issue a 12B order directly for reinstating the magistrate's determination as the trial court failed to satisfy the remand of the first appeal.
Thank you.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay. Our next case on the docket is State v. Sherman. Mr. Gustafson, good morning. Would you like to reserve some rebuttal time?
I would, 3 minutes, Your Honor.
3 minutes?
I'd like to
Okay.
apologize to the court for being late this morning.
I was in the traffic too this morning. I get it.
Please, the court, opposing counsel, Derek Gustafson, represent the appellant, Ian Sherman. So in this matter, Sherman, in our opinion, was not credited with the appropriate amount of jail time credit, pretrial confinement credit, I should say. Under State versus Fugit, Ohio Supreme Court has said crediting pretrial confinement is necessary to avoid an equal protection violation, because if we don't credit pretrial confinement, then persons who are confined pretrial will spend more time in jail or in confinement than persons who can make bond. And so I would submit from that principle that where an individual is confined for more than the sentence imposed by the court, when you combine post-sentence confinement and pretrial confinement, that an equal protection violation has occurred. And that's what we have here, because when you take the days that Sherman was confined on all offenses for which he was sentenced for pretrial, and the period of time he served in the Department of Corrections, he served 666 days, which is beyond the 18-month concurrent sentence that was imposed. Now, the state takes the position and says that he doesn't get credit for 119 days that was served on the B-21 case, which occurred prior to his being locked on the B-23 case, which is the case we're here on. And I take issue with the term unrelated, because Sherman was sentenced to 18 months concurrent on both cases at the same time. So the court fashioned a single sentence for both cases and imposed it at the same time. I submit that those are related offenses because there is a single sentence for both cases. It is no different than a single sentence for 2 counts in an indictment. So the judge selected concurrent time, and the proper credit is 269 days. Had Sherman been credited for 269 days in the B-23 case, he would have been released August 4th, and he would have served 547 days, i.e. 18 months. It seems to me that when 18-month sentence is imposed, that's what we serve. And I think it's pretty clear when you start looking at Fugate that that is the correct answer. And specifically, the language comes from paragraph 22, near the end of the opinion. When a defendant is sentenced to concurrent terms, credit must be applied against all terms because the sentence is served simultaneously. If an offender is sentenced to concurrent terms, applying credit to one term would, in effect, negate the credit for time that the offender has been held. To deny such credit would constitute a violation of equal protection. Therefore, we hold that when a defendant is sentenced to concurrent prison terms for multiple charges, jail time credit pursuant to 29-67191 must be applied toward each concurrent prison term.
Was that case multiple charges or multiple cases?
Multiple cases. So in Fugate, he was receiving stolen property, sentenced to community control, then got a new indictment, violated, held. I didn't find in the opinion anywhere whether his credit that was applied towards the community control sanction came from pretrial confinement in the first case or pretrial confinement in both cases or just the new indictment.
But
it was
same factual scenario.
same factual
not-
pattern, 2 separate indictments, community control violation, and then sentenced for a new charge. And the trial court in Fugate applied the credit only towards the probation violation. So
Can you so just to help me out, so he was on community control for having weapons under disability.
yes,
And then while he was on community control, he was indicted for having weapons under
Yes.
disability. So how are they related?
because they're sentenced at the same time, single sentence of 18 months concurrent.
It's the actual sentencing.
Correct.
It's not that they are related in time or
Correct.
anything like that. It's that the judge sentenced and said the word concurrent at the time of sentencing.
That's what makes them related. So had she sentenced him in 21 to a prison term and then he commits another offense, they're not
But
related.
is that what related means? I mean, I thought related had to mean that they were related somehow in.
In Fugate, were the cases related in some way other
No.
than, so it's the same factual scenario?
Same factual scenario. Yeah, and I think also when you look at the statute on credit, it uses the singular terms, but what's also clear is that on our rules on construction, the singular includes the plural. So it only makes sense to me that when you talk about credit for offense, it actually should mean offenses when we're talking about concurrent. And what struck me about this case is when I thought about it, well, what if the judge had crafted the sentence differently? What if the judge had said 9 months on the B-21 case and 9 months on the B-23 case, but I'm going to make them consecutive? How would the credit be applied? Well, he would have got 269 because he was held 119 on B-21, so he'd have been entitled to 119 on B-21, and then he was held 150 on both B-21 and the 23 case, so he'd have gotten 150 on the 23 case, and he got 269 credit, and he'd have done 547. Now, why should it make a difference whether it's consecutive, concurrent for the exact same amount of time, how we apply the credit? The only way that makes sense to apply the credit so we get an equal, just result is he gets 269 for both, and I think Fugate mandates that.
Okay.
And then I think the last issue would be is the state may say, well, the court has some sort of discretion to fashion the credit as part of their sentence, and this court has said in State versus Gregory that you don't do that the credit comes off it, the court imposes the sentence, and now we just figure out how much time has previously been served. So I think the rule is clear there. All those factors together, I think there's been an equal protection violation, and that he's entitled to the credit. Now, we can't unring the bell because he's already served it. However, I believe his rights are at issue here because the start date for his PRC, which is 18 months, begins in November as a result of the failure to credit, when it should have begun in August. So we would ask the court, if it grants the credit, to, as part of the decision, state the start date for his PRC, which then affects his end date, which would affect his substantial right because he would no longer be under supervision of the adult parole authority.
So you're saying the start date for the PRC,
Should be August 4th of 2024 as opposed to the November 30th date of 2024, which is the current start date.
okay.
So we do believe there are rights still at issue here.
Is that even something this court can do, though, address the PRC date in terms of? It seems like we don't even know how much PRC he's going to serve, right?
The court can award the credit, and one affects the other. So if the court were to say his sentence imposed should have ended August 4th, that's going to affect the start date. So I think one flows from the other, so I think the court does have authority to do that.
All right.
I don't have anything else unless the court has any further questions.
No.
Okay, thank you.
Thank you.
May it please the court, counsel, the matter before you is moot. Mr. Sherman has served the entirety of his sentence, and he was released on November 30th of 2024. The Ohio Supreme Court has noted that once an offender has completed the entirety of their sentence, that any alleged error related to the calculation of the jail time credit becomes moot as there's no longer an existing case or controversy.
Well, it seems like Mr. Gustafson was trying to save the mootness with the whole PRC thing.
Right. And I'm not certain that this court can change the PRC because that is related to the actual exit date of the defendant. So that cannot be altered. He actually did leave custody on November 30th of 2024. This court can't say he left.
Well, I think he's
different-
saying that, in effect, the PRC termination date would be earlier.
But termination date, isn't it based on the release date? Or would the court just change that? If the court believes that is possible, then I will concede that.
Okay.
Okay.
So you're saying it's moot because he was released, but if there is something that has to do with this PRC, then
If there
maybe
is.
not.
But if it wasn't moot, how would you address how is this case different than Fugate?
I think that there is a basic misunderstanding with Fugate that I just heard. So Fugate provides that when a defendant is held on multiple offenses and is later sentenced concurrently to concurrent prison term stemming from that offense, jail time credit pursuant to 2967.191 must be applied against each concurrent prison term. In that case, both of those charges or offenses were served at the same time, and the trial court attempted to give credit on a concurrent sentence to just one of the charges. So the trial court attempted to give credit on the probation violation and not the other charge, which would have in effect nullified the concurrency of the sentence.
So in effect, it's a factually different circumstance.
Yes. So, and actually, paragraph 18 of Fugate gives really helpful information in this case. So after providing a transcript verifying that the defendant was held on both offenses, they gave this sentence. As the sentencing hearing transcript indicates, Fugate was indeed held in custody on the burglary and theft charges and for the violation of community control, and is therefore entitled to jail time credit against each concurrent prison term. So there are three takeaways. Some more basic than others. 1, each offense has a separate prison term. 2, defendants held on multiple offenses are entitled to jail time credit on each offense in which they are held. And 3, that jail time credit is accumulated separately per offense.
So that's the important part there?
Yes, so why would you have Supreme Court go through the time and effort to go through the transcript to figure out whether he was held on all of the offenses? If it was sufficient just to say he was held on one offense, he should be credited on all of the sentences, if that makes sense. So it's important that he was held on both of those charges to receive credit for both of those charges for the concurrent sentence. So when we determine how those concurrent sentences are calculated, we can turn to the Ohio Administrative Code, so 512204F. And so after reduction of jail time credit for each offense, the release of the offender is based upon the longest definite minimum and/or maximum sentence or stated prison term. And in this case, the longest sentence after taking out credit was the 18 months minus 150 days that Sherman served. So Sherman cannot be credited the additional 119 days because those days were served on the 2021 case. And as the trial court noted, the law does not require a defendant be given additional days of credit for time he served pretrial on another unrelated offense. So while Sherman got the benefit of concurrent sentencing forward, that he could accumulate time served on each offense he was serving time under, he's not guaranteed the most concurrent sentence. And he was given all the credit that he is entitled. The state submits, number 1, the matter is moot, but number 2, in the alternative, if the assignment of error is without merit, it must be overruled. And then decision of the lower court should be affirmed. Are there any further questions from the panel?
No, thank you.
Oh, thank you.
Thank you.
Thank you.
Mr. Gustafson, you have about 7 minutes.
Yeah, I don't have that much material for
All right.
the court. With respect to the distinction that counsel made regarding Fugate, I think it's one without a difference. So in Fugate, they took the pretrial confinement and applied it solely to one charge, one indictment. In this case, the court apportioned it among. I think that's a distinction without a difference.
Well, so what she said as to that last sentence of paragraph 18, isn't that directly on point? Isn't that kind of dispositive? You only get credit for the case that you were serving the time on?
Well, he was serving time on 21. He's also serving time on 23. And
I mean, it seems like in that case, in the Fugate case, he wasn't getting credit at all on one of the cases.
so I heard counsel say if he's held on one offense, he gets credit on both, and that's what we're arguing here. And what I find stark about this is the state never acknowledges or mentions the fact that my client has served more than 18 months. Is an 18-month concurrent sentence supposed to be 18 months in confinement? Can we agree on that? If that's the principle, then we need to adjust the credits such in a manner that an 18-month concurrent sentence is 18 months, not 666 days, which is 119 days longer. I have a fundamental problem with the math because an 18-month sentence in my mind is 18 months. I don't know how you drive around that elephant. I mean, it's just, that's what the sentence was, 18 months. So he should be confined for 18 months somewhere. Pretrial is this hunk. Department of Corrections is this hunk. So he was confined for 269 days on both of these offenses. He should get credit for 269 because they're concurrent. It's simple, because otherwise, had he been out on bond on both cases, how much time would he have served? 547 days, 18 months. So because he's a poor man, he's going to serve 666 because he couldn't make bond. That's the equal protection violation, all day long. I don't see any argument that gets around that, however you phrase it. The troubling part is because, yes, he was held on B-21 before he was held on B-23, but the connection between the two is the concurrent nature of it. And I also think the plural definition within the credit statute itself. Offense also means offenses, and I think there's a reason for that, because when we're talking concurrent, we're always talking multiple offenses, whether it's multiple indictments or multiple offenses within a singular indictment that a defendant is being sentenced for. So with respect to the mootness, I think we do fit State versus Jones in this matter. We did ask this court for a stay, and a bond pending appeal, which for whatever reason the court denied, so we obviously didn't submit to no longer the incarceration voluntarily in any way, shape, or form. Had the court granted that, there wouldn't be a mootness issue with respect to that. We think we fit with all those parameters, and again, by adjusting the start date affects his PRC date, which affects substantial rights. So I think we fit within Jones, which is prior opinion of this court on mootness, and that's all I have, unless the panel has any questions.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. All right, that concludes court for today, except we do have a Zoom argument that we will be starting with shortly online. Thank you all.